Let's now bring you more developments in the ongoing trial of Nnamdi Kanu, the leader of the Indigenous People of Biafra, IPOB. The Federal High Court in Abuja has admitted the death certificate of former presidential aide Ahmed Gulak as evidence against Kanu. The prosecution alleged that Gulak, who served ex-President Goodluck Jonathan, was murdered in Imo State on May 30th, 2021, after Kanu, in a broadcast, ordered his followers to deal with anyone violating his sit-at-home directive. The Indigenous People of Biafra has also denied any involvement in the murder of Ahmed Gulak.
The statement issued by IPOB's Media and Publicity Secretary, Comrade Emma Powerful, the group rejected claims linking the Biafra group to Gulak's death. Meanwhile, the Department of State Services has strongly denied claims that Kanu is being held in solitary confinement. What does this mean for the case? We're now joined by legal practitioner Evans Ufeli. Warm welcome to you, Mr. Evans Ufeli, and thanks for joining us for Breakfast Central.
Yeah, thank you.
Let's start with the claim of the DSS refuting Nnamdi Kanu's detention and solitary confinement. How did this even come about, and what does the law say about in what situations do you hold a detainee in solitary confinement?
Well, solitary confinement is meant for hardened criminals, people who are terrorists or who have the tendencies to be very violent, even in detention, that it is a security risk to put them in prison to cohabit with others because they can lose their mind at any time. They can be very violent. They can become a risk to even the prison warders. So they put them in solitary confinement.
So the question is, IPOB has been proscribed as a terrorist organization. So it's the DSS within its rights. If they have admitted
to have kept him in solitary confinement.
To have kept him in solitary confinement.
No, I don't think Nnamdi Kanu is of that posture. Okay. Even though the federal government declared IPOB as a terrorist organization, we know that IPOB were not in that class because we have terrorist organization in Nigeria with the Boko Haram, the ISWAP, the Lakurawas, and the rest of them. We know their modus operandi, and their modus operandi is clearly to exterminate humanity. Okay, IPOB is not that. That's not the objective. They are a secessionist group. Okay, how be it that their agitation sometimes result into violence, but you cannot say that it's a terrorist organization. I mean, when the federal government proscribed them, as at the time they proscribed them, some of the terrorist organizations in Nigeria, the bandits and all that, were not even proscribed. It was when they went to get the Tucano jet that the US said that you cannot take this jet to Nigeria unless you have gone to officially declare those bandits as terrorists before you can even move it to Nigeria, because it is not used against any other organization other than terrorist organization. So you have to do that first. I mean, even as at that time, before that time, the federal government had already proscribed IPOB, which was not even a terrorist organization, in my estimation. But we know the politics played around this, and I don't think it is right to keep Nnamdi Kanu in solitary confinement. You know, he's undergoing trial right now.
Yes.
Okay, so why is he not remanded in prison custody, which is the normal thing to do? Put him in prison. Every inmate.
I mean, they'll say he's a high-profile prisoner and a flight risk because he has jumped bail in the past.
He didn't jump bail. Nnamdi Kanu didn't jump bail. He was on bail in his residence when
there was an attempt on his life.
Army came there to boggle the place, killed his parents.
And he had to.
Yeah, because today we are admitting in evidence now that it was his order that led to the death of Gulak. Now the death certificate has been admitted in evidence. Well, yesterday a lot of people were jumping and said the admission of a document in evidence does not mean you have won or lost the case. It just means that
the person is dead.
The person is dead, and the court have admitted an evidence that is alleged to have been the outcome of an order made by Nnamdi Kanu.
The court hasn't made any pronouncement.
No pronouncement.
But how significant is it? The court's decision to admit this piece of evidence, the video recording that we talked about. I don't know, we haven't talked about that yet, but the video recording and the death certificate of Ahmed Gulak. How significant is it?
It is one thing for a court to admit a piece of evidence. It's another thing to determine the weight that will be placed on it. Now, majorly,
or the interpretation.
Yes, majorly, every piece of evidence was not objected by the adverse party, Kanu Agabi and the rest of the legal team of Nnamdi Kanu, Aloy Ejimako and the rest of them, did not, object it, okay? So it went into evidence. Now, the reason, the essence of admissibility is relevance. If the piece of evidence is relevant to the fact in issue, the piece of evidence will be admitted. Now you could have a fact in issue, you could have evidence relevant to the fact in issue. You can have some evidence that are not relevant to the fact in issue, but they are relevant to the relevant facts. So all evidence in that category can be admitted in evidence. But it does not mean that the said evidence now have determined the case. Because I saw the posture in yesterday, so many persons, though not lawyers, okay, who may not, we could forgive them their trespasses because they are not lawyers. We're talking about how that the admission of that evidence alone has sealed the case. No, this is, is a serious allegation of murder we're talking about, okay? And for you to convict a person of murder, there must be a nexus between the defendant and the act itself. Okay, he made an order, according to you, that people should be dealt with. People that refuse to obey the certain order. Okay, you said that was what led to the death. But during cross-examination, because see, what we have now is the defense have not even opened their case.
Right.
What you have is just the prosecution. The prosecution opened the case and they are tendering evidence accordingly. Okay, so and the matter was also stalled. That's because the document that Kanu Agabi applied from the police have not been given. All
right, let's pause on that. We'll come back to talk more about this document. We'll go on a very quick break. And when we return, we'll still be exploring more conversations regarding the latest on Nnamdi Kanu's trial. Stay with us. Welcome to Breakfast Central. We're still joined by Evans Ufeli as we're exploring the latest on the trial of Nnamdi Kanu. Now, before we went on the break, we were speaking about the defense applying for a certain document. Please go ahead.
Yes, the defense team actually applied for a document, from the police of that state, but they've not been able to get this document. And trial could not proceed because of those issues, and they asked for an adjournment. The prosecution objected to the fact that trial should continue because they need to. The practice direction talked about day-to-day trial, so there should be no space. And the judge looking at the issue knew that they've gotten to a point. Justice James Omotosho of the Federal High Court, Abuja, stated that they need to have that adjournment to enable all parties get all documents required for the proceedings to continue. I think it was necessary that adjournment, but if you look at the trial has been accelerated because they've been
unlike before.
Yeah,
under the previous judge.
The previous judge, but now because there's an order for accelerated hearing, okay, they are making a lot of progress. Okay, very soon. The prosecution still have 5 witnesses to call. 5 witnesses. So those 5 witnesses, maybe it will take maybe another 4 or 5 adjournments. Okay, then before the defense will open their case. But the frequency of adjournment, the closeness in the dates we're having, we're going to dispense of this case before the year runs out.
Well, that's exciting. So what are the next steps we're expecting with the case? They've written to the police, the date has been adjourned, so when they come back to court...
They're going to take the other witnesses, the prosecution.
Right.
Because the defense have not opened their cases, the prosecution have opened. So the prosecution will have to bring in everything they have against him. Okay, in the course of doing that, the defense counsel can object some of the evidence, okay, and then
But does the defense counsel get to cross-examine?
Yes. They will cross-examine them. Each of the witnesses will be cross-examined. The reason for cross-examination is to test the credibility of the evidence, either oral or documentary.
Yeah, but these witnesses have been using anonymous names, so
yeah, there's a need to protect. Yeah. But even under our law, there's a law now before the National Assembly talking about witness protection. Even in civilized democracy, they mask them.
Yeah.
Sometimes they alter their voice. Okay, so you're not able to get their true voice to protect them. Sometimes they shield them from, because when you, in this kind of, it's a high-profile case. It has a lot to do with regional,
treason,
so many sentiments, and yes, and the penalty for the case is also way far. Capital offense, capital punishment comes with it. So there's a need to protect every person that should be protected, and there's a need for the court to come to justice. That's the most important thing. And the court is doing that as we speak. The trial is going on well. The witnesses are available. That's the prosecution witness as we hear. So they will continue to give the evidence and they will be cross-examined. Okay, whatever it is you bring to court, including the evidence of death and everything, will go under the fireworks of cross-examination. Because it is cross-examination that
vice versa. When the defense also brings the witnesses, the prosecution.
When the defense opens their case, they'll call witnesses. Those witnesses will be cross-examined by the prosecution. Okay, so it is after the examination in chief, cross-examination, and if there's any need for re-examination, for clarity of ambiguity and every other thing, after the examination, then the defense will close their case. And once they close their case, the court will adjourn for adoption of final written address. And after final written address, the court will adjourn for judgment.
Typically, how long will judgment take? Is there?
No, you can't really tell how long it will take, especially now. I don't know how many witnesses the defendants have. I don't know how many witnesses, but this prosecution still have 5 witnesses to deal with. People who witnessed whatever will support the case of the prosecution.
And it's one man, the judge, that would determine. You don't have a jury system.
No, you don't have a jury system. It will determine based on the evidence before the court. But the fact that you have 5 witnesses does not mean all the witnesses will be called. They may decide to dispense with some if they have covered the ground as possible.
All right, still going back to the detention situation, we've seen conflicting reports, of course, within Nnamdi Kanu and his lawyers, who right from time have been letting us know that they hadn't been getting access to their client, and now the DSS giving us different reports. Do we have a current position as to his detention situation?
The last one have been cleared. It was a lawyer, Jimako, that put out that on social media that they did not allow the lawyer to see Nnamdi Kanu. But what actually happened, Kanu and Gabia said and explained what happened, that he actually went there before 2 o'clock. He's supposed to go from 2, but went before 2. So they didn't allow him up until 2. And he explained to the court. And then the court had warned that Aloy Jimako and others who put out things on social media should verify things proper. Not like he was asked not to see Nnamdi Kanu, but as at the time he came, he could not see him that time because they have their own administrative protocols.
Yeah.
But eventually saw Nnamdi Kanu after 2 o'clock.
And the solitary confinement bit of it, do we have clarity in that as well?
Yeah, the solitary confinement, the allegation is that he's in solitary confinement, but the DSS are saying no, that is not there. I mean, they are not going to take you, who is a visitor, into the detention facility. They will just bring him. So you can't even know whether it's in solitary confinement or it's only Nnamdi Kanu himself that can say he's in solitary confinement.
But if they are saying that he was in solitary confinement, it will be because he's the one that told them.
Before now, earlier on, it was when he was during the extraordinary rendition.
Yes. He
was actually put in solitary confinement because he said it then. Okay, when the trial was when they were going to court then,
under Justice Inyako.
Yes, even when the Supreme Court said then that the extraordinary rendition was irresponsible, that the federal government going to his house to when he was on bail and all that was also an act of irresponsibility. The Supreme Court actually condemned everything they did to him. And then the Supreme Court ordered for the case to start de novo. That's this one now,
yes.
to start afresh. And that is exactly what is going on. What is going on now is the order of the Supreme Court. And the order also said that there should be accelerated hearing. So you have it's the order of the Supreme Court that this is running on. Yes, this whole case is running on.
All right. Do we expect any sort of response or ongoing or maybe interventions from the international community, especially owing to the fact that he is not just a Nigerian citizen? Are we expecting maybe the international community will jump into the conversation?
Well, the position of the international community is not very clear because they have not made public statements to that effect that I have seen. But he has a dual citizenship. I mean, he's a British citizen and he's also a Nigerian citizen. But now, it is alleged that he committed offenses. Okay. Part of their defense was that those offenses were not committed in Nigeria. That you cannot even litigate, you cannot even convict him because he was not in Nigeria when those issues. So they went and amended the charge. Okay, then. Okay, and then the charge should have been amended on several occasions. So if you have to convict someone or try someone, it must be an offense that is committed within the territory of the said country. This wasn't. I'm not preempting the court. Of course, we can talk about the case in court. The only thing we cannot do is to preempt the outcome.
Yes.
Nobody can preempt the outcome. But as at the time those offenses were committed, he was not in Nigeria. That is part of their defense. Okay. So we'll see how it goes, how the court will interpret that, and from where he was then, the dual citizenship will not play a role based on the fact of the case. What I mean is that it is Nigerian government that is prosecuting him, not the UK government. Okay, so they are going to prove beyond reasonable doubt, because that's the standard.
And this,
beyond reasonable doubt that what he did was treason, or treasonable felony, whatever it is. And that there's murder to it and all the charges, everything. And the prosecution must prove every of the charge one after the other. Anyone that fails, fails against the prosecution. Okay, so to have him convicted, all the charges will have to be proven
beyond reasonable
doubt. The one that fails will fail against the prosecution.
Before we wrap up, what implications does this have for Nigeria's criminal justice system? Because they say justice delayed is justice denied, and it had to get to the Supreme Court to enforce an accelerated hearing. There are thousands of cases out there that have been dragging for years. Would they set a precedent, or perhaps have an effect on the other cases, so we stop dragging our feet and would it change anything in the
Administration of Criminal Justice Act? Okay, the law we have now, every criminal prosecution, they're supposed to be based on accelerated hearing, because adjournment should not be far. Okay, but what you have that intercept that is the congestion of the courts. Okay, even the congestion also affects this particular case. Okay, the congestion of the courts and the fact that you have so many cases, few judges, few courtrooms. Okay, look at our population.
Are we looking at expanding the courtrooms and judges?
Yeah, expansion is critical. I mean, the federal government is recruiting judges. I think the names of new judges just came out. They need to do more, and they need to build bigger prisons, because before 2009, there were some offenses. There were some things that are offenses now that were not offenses then. Kidnapping, for example, we didn't have it even in our law books.
Wow.
Terrorism, we didn't have it. We are not that kind of people. Okay, before 2009, and some sundry offenses and all that. So, but from that time till now, you have layers, and the National Assembly have to, make laws to address all those crimes. Now they are added to.
So it means the net has been widened.
But the prisons are still the same. How many prisons have been built between 2009 till now? I don't think you have any significant. And that is why it got to a point when Aregbesola was Minister for Interior, he called on the state governments to come and take those inmates that committed state offenses, to come and feed them, to contribute to feeding them, that the federal government cannot be feeding inmates that committed federal offenses and they are not in prison. And then because we don't have state prisons, because I mean this is managed by the exclusive list, it's in the exclusive list, I mean detention and all that. Now he made that assertion to the fact that the state should contribute. That is like hitting on federalism now, because since you
it's a logical conversation.
It's logical. It's not because the federal government packed 66 items into the exclusive list and they have no competence on one. So at the end of the day,
let others you privatize it.
Yes, because in the US it's privatized, it's private business. Build the facilities, put everything, meet specification, then each image that you take, just like we have the JAM centers. The centers don't belong to JAM, they're individuals, investors. And as at that time, you pay 7 naira per candidate. So they could do that. Inmates, you pay a certain kind of money before you do that. So the only way for us to have good prison system is for us to have either privatize it or let the state handle it and let it be properly handled.
Right. Thank you so much for joining us this morning on Breakfast Central. We'll continue to see where this story leads. You know, and I'm sure that it's formed a major cause of discourse amongst lawyers, arguments back and forth.
We are following the case. I mean, it's a high-profile case. We have to follow. We also develop our jurisprudence. I mean, we are getting precedents from saying.
Okay.
Absolutely.